a community librarian here at Deschutes Public Library, and I oversee legal services for the county. I'm very excited to welcome two lawyers from Legal Aid Services of Central Oregon today, Charlie Allen and Lauren Gishto. They are going to speak to us about the expungement process in Oregon, and I'm going to turn it over to them now.
Great, thank you.
Welcome.
Come on in. Are you here for the presentation on expungements?
No, I will hear.
Oh, okay. Well, hi everyone, my name is Charlie, this is Lauren, and we're here to talk about criminal expungements. So Lauren, I'll let you start with the disclaimer.
Yeah, so we are attorneys and we work with Legal Aid Services of Oregon, but this presentation is just meant to be general legal information. It's not legal advice. We're not your lawyer. We can't give you advice today. And if you have any specific legal questions, you can always follow up by contacting our office or private attorney.
Great, okay, so what exactly does set aside do? So if there's an arrest or a conviction for a crime, a person who's eligible for a set aside, if they receive it, can say that they were never arrested or convicted of the crime that was set aside. A criminal history background check should not reveal the arrest or conviction, but sometimes it can. We'll get to that a little bit later in the presentation. And a lot of the collateral consequences of the conviction should go away. Condition on ownership or possession of firearms is lifted in both federal and state.
And just for clarification, when we say set aside, that's the same as what people call an expungement. So to expunge your criminal record is to set aside your criminal record. And so what a set aside doesn't do. So for immigration purposes, a conviction or arrest, it is getting a set aside does not affect the consequences in that immigration context. So it's really important that you get a certified copy of your court documents, the arrest documents, if you're going to get something set aside. Setting aside a criminal conviction also does not clean up your online reputation. Just because you've set aside a conviction doesn't mean that a website can't talk about your conviction. And there are some applications for professional licensure that require that you disclose even if a conviction has been set aside.
And so I do want to go back to the theme of the online reputation. I've heard from people that if you provide a copy of the signed order setting aside the conviction, a lot of online places will change what your search shows, but you have to take that extra step. So I'm going to talk a little bit about what crimes are eligible, because not all crimes are eligible for a expungement or a set aside. So for example, Class A felonies, with the exception of some limited marijuana crimes, you cannot get those expunged. Same thing with sex crimes. There's a very, very small number of sex crimes that can be set aside, but the vast majority of them cannot. A third is traffic crimes and violations under the vehicle code. Another is crimes involving elder or child abuse, criminally negligent homicide. And then this last one isn't necessarily things that you can't get expunged, you just can't get them expunged in the Oregon court, right? So federal, tribal, or other state convictions are going to have different laws that apply to them. And so you're going to have to go through a separate type of process in either the federal court or the tribal court or another state's court to get those set aside. So this presentation is really limited to getting Oregon state criminal convictions set aside.
So crimes that are eligible would be, except for the ones that were previously mentioned. It includes arrests, citations, acquittals, and also the contempt. There's specific statutes that apply to marijuana convictions and to guilty except for insanity. So those are their own statutes that have a little, some different rules, but they can be expunged as well.
And so it can be really confusing because while it's the same general process for all of these, slightly different rules apply to each one. So it's already a really difficult law to read. And then you add to that then you've got all these separate laws. There's a separate law for the guilty except insanity expungements, and then a separate law for the marijuana conviction expungements, and then there's a different set of rules about who doesn't qualify for acquittals and arrests and convictions, so it's really complicated. And one of the things we'll hope you do is that you reach out to potential providers and help you figure out whether or not you are eligible. So one of the things that's important understanding is, so for example, Class A felonies are almost never expungible, But then to determine how quickly after the conviction you can get something expunged, you have to figure out what sort of crime it was. Was it a B felony, a C felony, an A misdemeanor, or a B or C misdemeanor contempt, And so the most serious, the B felony, you have to wait 7 years and have no other convictions to be able to set it aside, C felonies, 5 years and no other convictions to set it aside. An A misdemeanor 3, or a B or C misdemeanor, it's 1, as well as a contempt, which is technically not a crime, but quasi-criminal, and hence it's included in the expungement statute.
And there's also some other rules, and again, this is for convictions. You can have a single violation, and it's not considered as a conviction that would prevent getting an expungement during that either 7, 5, 3, or 1 year period. And they also don't count motor vehicle violations. If you had a conviction that was set aside, they still consider that. So you can't just get rid of one and then go back and get rid of the next one. They still count those during that look back period. And you cannot have any current cases pending or new charges, new warrants. And there's also some specific rules if there's probation that was revoked or you were sentenced to incarceration, that also changes the clock a little bit. And it usually goes from the date of release or the revocation of probation, not from the date of the conviction.
And then I just want to follow up on one thing Lauren said, which is what's a violation, A violation is any kind of ticket that you get that you admit to or that you've been found to have admitted that's non-criminal, So, the ones we think of most commonly are the ones that are accepted here, Motor vehicle violations, So a speeding ticket or a parking ticket, but there are other types of violations that aren't those things, I think the one I've most commonly seen is kind of violations for camping without paying a camping fee, Those are what a violation are. As a person able to set aside or expunge a record of arrest.
And so this is an arrest with no conviction, just arrested, weren't convicted.
So if there's never an accusatory instrument filed, so what does that mean? So when a criminal process starts, the district attorney's office files an accusatory instrument, which is an information or an indictment that says, we are charging this person of committing this crime on this state, And 60 days after the DA's office says, we're not going to do a prosecution, then, we're not going to file a charging instrument, then you can move to have the arrest set aside. Now, that's at the very beginning, but police said, the DA says, police recommended this to us, we're deciding not to follow on it, wait 60 days, But let's say the DA does file an accusatory instrument, well then, it's once the case is dismissed, So potentially as new evidence comes up, DA decides this is a bad case, they're going to file something called a motion to dismiss, and once the judge signs the order dismissing the case, then you're immediately eligible to have the arrest set aside. And then there are some weird tweaks for DUIs. So for example, a DUI where you weren't convicted because you went through diversion won't be eligible for an expungement, So diversion is a program where you plead, guilty to the DUI, and then you have to do a series of things. And if you do that, the case gets dismissed, So in that case, the DUI will get dismissed, but the arrest will continue to show up on your record. You cannot get that expunged.
And so let's say you applied to and asked the court to set aside a conviction or arrest, can the court deny it? And in some situations, they can. So the prosecutor has to file an objection within 120 days of when you ask the court to set aside the conviction. The court's then going to hold a hearing. You go and you present your evidence as to why you qualify. Prosecutors going to present evidence as to why you don't qualify or it should be set aside. And then the court has to make written findings by clear and convincing evidence. So it's a high standard that the circumstances and behavior of the person create a risk to public safety. The court can only look at your behavior from when you committed the conviction you're trying to expunge until the date of the hearing. So they can't look at things before that. And they can only consider certain types of things. So criminal behavior, certain violations of the law. They're not allowed to consider if you owe money. They're not allowed to consider, motor vehicle violations. So there's some restrictions on what the court can and cannot make their ruling based on.
And I will say that from what I've seen, it's pretty rare for the court to hold this sort of hearing. When the DA objects, it's usually just purely legal arguments about why this particular person isn't eligible for it under the expungement statute. It very rarely gets into these sorts of factual determinations where you present evidence about your conduct and they present evidence about your conduct. It is possible.
But usually it's, if you do qualify, usually you get it. And if you don't qualify and you apply, then the court will grant it.
I just, the reason I say that is I hope that this is not something that will discourage people from looking into it and applying, because it's pretty rare to see this sort of hearing actually. So how exactly do you get things expunged? So here's a link to some forms. I will say that I know that a couple of counties, Multnomah County in particular, have a specific process and set of forms, right? And you're gonna move to have your conviction expunged or set aside in the county where you were convicted, right? So if you live here and then you don't file it into the Deschutes County Circuit Court if you were convicted in, say, Crook County, right? So you file it in the county where the conviction's in. And in most counties, you'll be able to use this form here. And you shouldn't have to pay a fee when you file this paperwork with the court.
And so the forms, they're online, they're free. And if you file with the court, they should not charge you a filing fee. That is also free. The one expense, though, is that you also have to get fingerprinting and you have to submit the fingerprint cards along with a specific form to the Oregon State Police. And if you're trying to set aside a conviction, you have to pay $33 for that. So that's the one, expense that comes along with trying to set aside a conviction. If you're trying to just set aside an arrest, then you don't have to pay that fee, but you still have to do the fingerprints and the form. And we have a link that can take you to those instructions and that form.
So this is kind of a flow chart of kind of what the different steps in the process are. And the flow chart says 90 to 120 days. That will depend a lot on the county you're in. My experience is 90 to 120 days is on the optimistic and short side. But that's the hope, right? So you start with Oregon State Police and you do the fingerprint processing. I do that that 6 to 8 weeks is actually pretty accurate in my experience there. Then they forward those fingerprint results to the district attorney's office, 1 to 2 weeks. Then the district attorney confirms no objection to set aside time. And here, this is one place where they can take more than 1 to 2 weeks, just because district attorney's offices have a lot of work on their plate, and this is not always the most urgent thing for them. And then hopefully they'll notify the court quickly that they don't object. Once that happens, then the court will process the no objection and forward the order for the judge to sign. And once that's that'll be placed in the judge's queue for signature. The judge will sign the order, and the clerk will process that paperwork once it's signed. And here, this is another place where the time time frame will vary hugely from county to county. just like district attorneys, judges have a lot on their plates. And then, court clerk will send if you have a pro bono attorney working with you, they'll send the pro bono attorney a copy of the order. And having done some expungements, I can tell you that it's really surreal because you'll be working on this case, you'll file all this paperwork into a case, and then all of a sudden one day you'll get an email that says, hey, an order's been signed in your case. And then you look up the case and it's disappeared. And you're like, I can't see this order, what just happened? So very quickly, right, the traces of this case can go away. And that's why they send a paper copy to the attorney. And that's, if there's no attorney and you're doing this yourself, they'll send one to you at the address that you have on file in this order to keep that up to date. Because if you don't get that order, you'll start talking to people about the case and the court might be like, well, there's no case like that in our records anymore, right? Because it got, erased from the court docket because of the order that got signed from the set aside.
And this timeline is also only if it's not contested. If it is contested, it's usually a longer process because they have to set the hearing and then the judge might typically out that hearing. And so I think Charlie mentioned a little bit before, so private online background checks don't always update as fast as like the board system if you get something expunged. So you can send them the information. And there's the Foundation for Continuing Justice. We included their information on here. They have great resources on how you actually go about trying to get your record updated properly on various internet websites and background checks.
And so here are some legal resources for you. We include a link to the Oregon Judicial Department's website on expungements, as well as the Oregon Law Help website on expungements. You can talk to attorneys. Legal aid here works pro bono attorneys to help people with that. I know that in Bend, Deschutes Defenders, the local public defender, will sometimes help former clients with expungements. And there's always the Oregon Lawyer Referral Service. So I think that's the one that will charge you, I think it's $35 for a 30-minute consult.
And that'll work for private attorneys. And so, the forms exist, the instructions exist, if people can file for expungements on their own. But if you're not sure or you have questions, we always recommend that you try to talk to an attorney to make sure you do the process correctly the first time and don't have to redo it.
And again, here's our contact information at Legal Aid. That's our Bend address. If you're in another county, there are other legal aid offices. So we're the office for Jefferson and Deschutes County. You can walk in, Monday through Thursday.
No, walk-ins Tuesdays and
Thursdays, 10 to noon and 1 to 4, and phone intake is Monday through Thursday, 10 to noon and 1 through 4. But I do see that we've got a question in the chat. Feel free to add to that.
One question, they're asking for that link, and I'm just on the OJB site and I can't find that expungements.
So it'd be under set aside. Oh, wait, which link?
Yeah, I'm on OJB Forms Center.
And I approved it.
Yeah, I can do a Google search for it.
It should be.
Yeah, because I was just down here. Oh,
Yeah,
here it is.
criminal arrest
Yeah.
record set aside.
So I'm just gonna put this in chat.
Great, but just generally, if you go to the Oregon Judicial Department's website, they have statewide forms on there. If you look under the criminal section, then they have the forms for set aside.
Yeah, and it will usually say criminal or arrest set aside process. And it's a little confusing because two mean the same thing.
Okay, yeah, you're talking about that earlier today.
Yeah.
Yeah.
Yeah, and it's also super confusing because in the civil world, set aside means something completely different than it does in the criminal world.
Yes.
So,
And there's also like landlord tenant eviction, expungements and set asides. So it can be a bit confusing. So you want to make sure you're in the criminal section, looking at the criminal set aside documents for either conviction or arrest.
yeah. Any other questions in the chat?
Nope, that's it so far. We can wait another couple of minutes. If anybody online has any other questions for Charlie and Lauren, go ahead and put them in the Q&A. Otherwise, you can contact Legal Aid Services of Central Oregon, or you can contact us at the Law Library here at Deschutes Public Library as well. Here we go. What is the distinction for the marijuana statute?
Yeah, the marijuana statute was essentially a recognition by the legislature that the marijuana laws have changed a lot. And so I've actually never done an expungement under the marijuana statute, but it's just a lot easier to get a former marijuana conviction set aside than other similarly situated drug convictions. So if you have an old marijuana conviction in Oregon, I really encourage you to reach out to legal aid or to Deschutes defenders or to just an attorney that does set aside, because there's a good chance that, you'll be able to get some help.
Yeah, and especially if it was like a felony possession charge, those are treated as less severely as other felonies now.
Well, yeah, the possession statute for non-marijuana crimes has even changed significantly in the last 10 years. So
Thank you both so much for being here. We really appreciate the information and the resources. This recording will go on our YouTube page. And again, if you have further questions, reach out to legal aid or to us here at DPL.
thank you so much for having us.
Always a pleasure.